Good? Okay. Ready? I'll call the meeting to order. This is the November 12th, 2013 meeting of the Fairfield Town Plan and Zoning Commission. This is our executive session. And the first item on our agenda are the meeting minutes from October 22nd, 2013. All the regular members are present. I believe they were all here for that meeting. Yeah, Commissioner Kelly was here as well. So, do we have a motion on the minutes? Motion to approve the minutes. Yeah. Okay, motion to approve the minutes. Yeah. And a second on the minutes? Second by Commissioner Jacobson. Comments or questions? No? They look accurate to me. Okay. If there are no comments, I'll call for a vote. All in favor of approving the minutes of October 22nd, 2013, signify by saying aye. Aye. Opposed? No one is opposed. The minutes are approved. Next item is 54 Sasco Hill Road, special permit and coastal site plan application of Love Where You Live Homes, LLC, pertaining to a new mixed-use office and residential building in a design commercial district.
Just to kind of landmark where you're at here, on the corner of Sasco Hill and Post, you know there's a new building under construction. On the opposite side of Sasco Hill, there's an existing office building, and if you go south one property, there's kind of a rear, it's a very skinny, long lot. There's a small office building there now, and this proposal is to replace that with a larger building with office on the lower levels and residential above.
Okay.
This is a special permit, does require public hearing.
Okay. Do we have a motion on this?
Move to public hearing.
Motion by Commissioner Jacobs, second by Commissioner Suter. Any discussion on this? None? Okay. All in favor of moving 54 Sasco Hill Road, special permit coastal site plan application of Love Where You Live Homes to a public hearing, signify by saying aye. Aye. Opposed? It's moved to public hearing. Next we have old business, which is 2500 Hillside Road, subdivision application of MTW properties for 2 lots in a AAA zone.
Yeah, Mr. Chairman, just to review what was submitted or described at the hearing, 2500 Hillside Road is the subdivision application address. This property contains 17.78 acres and is located between the Merritt Parkway on the south and the Audubon Society on the north. The property is located in a residential AAA zone, as mentioned, which requires a minimum lot area of 2 acres. The intent of the owner is to subdivide the property, creating 2 separate lots. This property would be serviced by public water and on-site septic system. An inland wetland permit was approved on July 18th, 2013. A drainage report and a stopping sightline distance report was submitted and reviewed at the public hearing, and also was reviewed by the town engineering department, who submitted a report to the commission. Essentially, the engineering department commented on the report and found that it indicated the proposed 2-lot subdivision would appear to be meet all the town requirements. The applicant was requested at the hearing to supply the commission with a zoning data table. That table had been supplied or has been supplied and indicates that the proposed lot design is consistent with the applicable zoning design requirements that are on that list. Since the property is in excess of 4 acres, the provisions of the open space section of our subdivision regulation section 2.3 are applicable. The applicant has requested a dedication of open space. The primary reason for the request for dedication of open space are the location of the property, the size of the proposed open space, and the fact that the proposed open space parcels are adjacent to the property, again owned by the Audubon Society of Connecticut. The 2 open space parcels which are proposed would abut the Audubon property. These parcels total just over 10 acres, with portions of the property being upland. On Tuesday, September 10th, 2013, the Commission voted to recommend the proposed open space designation to the Audubon Society pursuant to our section 2.3.9 of the subdivision regulations. That, Mr. Chairman, is what was outlined at the public hearing.
Thank you, Mr. Devanczyk. Do we have a motion on this?
I'll move to approve.
Thank you. Commissioner Suter has moved to approve. Second? Thank you, Commissioner Jacobs. Discussion. Go ahead. Thank you, Mr. Suter.
This property has a long history. Commissioner Barrett described some of it during our last hearing. And the inland wetlands approval, conditional approval, goes into further and great detail about the history of the property and the conditions on the property. There's a lot of wetlands on it. The Wetlands Commission considered it an important source of fresh water, important habitat area, and for those and other reasons, the earlier proposals were denied. It seems to me that this particular proposal, proposing only 2 building lots, is one which will have the least impact on this sensitive area. And both of the parcels are well in excess of the minimum areas required for a parcel in that zone. Orapuli has issued a positive report on the drainage and other aspects of the property, and the Audubon Society is happy with the very large parcel over 10 acres that's being, excuse me, that's the wetlands area, but they're very happy with the acreage that they're getting. So I think, and the stopping site distances that we're at, more than adequate. And I think in general, it's just a good application.
Thank you, Mr. Suter. Any other comments? Yes, Commissioner Jacobson.
I agree. I think it's the best use. I know the Audubon Society is very happy that they're going to be able to preserve some of the wetlands, and I agree with everything Commissioner Suter said, and I will support it as well.
Just a question, were there any conditions other than the standard conditions mentioned at the public hearing? I don't have a note that we had anything.
No, I mean, we'll include, as we usually do, all the engineering comments.
Yep.
Which most of them were addressed at the hearing. I don't know of any other than those
Okay.
that were discussed at the hearing anyway.
I had to do
A question, yes. Okay, sure.
Is it appropriate for us to put a condition on it that as much as possible they preserve those really nice stone walls?
Sure.
Because they are really nice.
You can make
And
a
they're like
recommendation.
300.
Matter of fact, I think that was mentioned at the
It was
public
mentioned,
hearing.
and they agreed to it, so I don't.
Yeah,
think-
so yeah, I mean, if you want a condition that to the best of their ability, that the stone walls remain intact. I think they mentioned they had to breach one of them
I
just
know,
to get the
but
access
at
in there.
least they can make the effort, which they
Yeah,
are.
they did, if I remember correctly, they did state at the
Yeah.
hearing that they really
Well, they're
maintained.
350 years old.
You're okay with that, Mr. Suter, since
Yeah,
you
that's
actually made the
fine.
motion? Okay,
Yes.
we'll have that as a condition.
All right.
Any other comments, questions, discussion on this item? Yes, Mr. Wagner?
At the hearing, they did comment that the one stone wall had to be removed to make way for the road,
Right.
and that the stone wall that was on the edge of the property was a property line, and that they would not disturb that. So yeah, I think it's important that that be a condition of approval.
Okay. Yes, Mr. Jacobs, yes.
While I hate to see properties like this subdivided, I cannot see any reason to not allow it. They've met the regulations, and therefore I would have no choice but to vote in favor of this application.
Okay. Anyone else? Okay. The motion's been made, the conditions, on the standard conditions, as well as the one about the stone wall.
Yes.
On the motion. So I'll call for a vote on 2500 Hillside Road subdivision application of MTW Properties LLC for 2 lots in the AAA zone. All in favor signify by saying aye.
Aye.
Opposed? It's approved unanimously. Next item on our agenda is a compliance application, 427 Stilson Road, compliance application of J. Braun to modify an approved sign plan.
Firstly, I'm going to hand out, I don't believe I included it in your packet, but this is the, to the extent you're not familiar with it, this is the sign that we're talking about. This sign was originally approved by this commission in 2009, and what they're asking you to consider is to basically rotate this sign 90 degrees. You need to grab one of those there. Just take
Oh,
all
I'm
the
sorry.
It's the sign right now is parallel to the traveled portion of Stilson Road, and they're requesting that it be rotated 90 degrees so it be perpendicular to the street. It would require a two-thirds vote from this commission, as did the original approval, since the sign is less than 25 feet from the property line. It will be nearly at the property line, or approximately 10 feet from the face of the curb. So it's not a new sign so much as it is to get it approximately 5 feet closer to the street and turn it 90 degrees.
Does when the sign as turned is sitting in place, to what extent is it a visual obstacle to any traffic?
I don't believe that it would. Your package does have a site plan in it. It's in the center of kind of like there's kind of like a circular driveway that it's in the center of, but the main parking lot is actually to the rear of this building, and that driveway is offset substantially from the this sign in the major sight line for that driveway would be looking to your left, and this sign is to the right of that driveway.
That's what it seems to be.
Yeah. Oh, we don't have a motion yet, but you have a question for staff or something?
Yeah, so
Okay, go ahead.
the site plan that we have shows the sign in its current configuration,
Correct.
not in the proposed configuration, right?
Correct.
And the light that they propose is to shine upward?
Correct.
Okay.
This old sign meets all this blue red.
Yeah, it was approved in '09, and there was an exception granted at that time to allow it to be less than, two exceptions. One, to allow it to be less than 25 feet from the street, and the other to allow a less than 6-inch letter height. So in order to maintain a reasonable size, the sign is approximately 4 by 5, excluding the decorative top.
Any other questions for staff, or do we have a motion to do something with this? Approve it, deny it, table it? Talk some more about it? Why don't you do the sign motion,
Okay.
Mr. Jacobs?
Motion to approve with conditions.
Okay, that's good. And anybody second that, or you want
You want to know what the conditions
to?
are?
Yes.
Or we're just going to do any
No, but
conditions?
you make it, yeah, why don't you want to add the conditions now, go right ahead.
Or I'll go into a more of a history. This sign was, when they came to us, they originally were denied many, many times before we approved. What I see as a problem on this sign now, as a condition that I would be worried about, or one is the light facing up. We have a policy of dark sky that violates the policy of dark sky. So that light is, to me, a real issue. The other thing that is in our regulations has to do with our sign, all signs in the building being of, similar nature. They're running a dark blue scheme and then a light blue scheme. To me, it's got to be one or the other. So I would actually hope that they would take the dark blue scheme that they're using on the building and just take the light blue and paint it dark blue to match the signs that are on the building, so that the signs actually all are in the same color scheme and all match. And my only other question would be that when they rotate it, that it does not extend into the sidewalk, which I don't think it will. But
No, there's enough room.
Yep, go ahead, Mr. Alessi, Mr. Wagner, I don't know which one is first.
Sure.
I'll go ahead.
Yeah, so, I mean, without seeing the sign as proposed on the site plan, it's a little difficult to see how this is going to impact the the view, the sight lines coming out of the driveway there, you know, it looks fairly close to that, was it the northernmost exit, and very close to the road. As these cars are traveling down the roadway, vehicle exiting the driveway, looking to the left, they're going to be looking directly into a sign, and the cars coming on that right-hand side are going to be behind the sign. And I would agree that we're disfavoring upward-facing lighting as a policy matter, and that I don't think that this is consistent with what we're trying to do around town in terms of dark sky and downward-facing light. So I don't see how this fits in our signage plan. I don't understand why there's a need for it. Requiring a 2/3 vote to, you know, circumvent our regulations that everybody else has to comply with.
Okay. Are you asking me what?
No, it's more of a statement
Yeah, it was a
than a
statement.
question,
Okay.
although my
okay.
inflection was clearly
Okay. Right, it's a 2/3 vote because it doesn't comply with our
Of course,
regulations.
yeah,
Right.
and I don't understand why this building needs this sign to block traffic with an upward-facing light. I don't get it.
Mr. Lessie, you had some comments also?
No, I agree, and even if we were to take the light away, or downward-facing light, I still believe this sign is going to interfere with that driveway and the line of sight on Stilson Road. It's just too narrow, a garden or whatever they have there, and to put a sign that's 5 foot by 6 foot high, it's just going to interfere with the sight line coming out of that driveway. And Stilson and Black Rock is a busy enough intersection as it is now, so I'm not in favor of this sign proposal.
Anyone? Yes, Mr. Suter.
On the sightline thing, it seems to me that the sign, although, as Mr. Leslie points out, or maybe Mr. Wagner, it's hard to tell exactly how close to the road it comes. But the usual measurement we have for sightline distances is a driver is sitting at a height of about 3.5 feet in the vehicle and about 5 to 10 feet back, I think, from the edge of the road. This sign, after its turn, would be about 10 feet from the curb. So it's a close call, but
Yeah.
the sightlines probably may not be as great as we think.
I just want to.
Excuse me if I may.
Yeah, you can go ahead, Mr. Lessie.
I'm looking at it here on the map, and I'm looking at it on Google Earth, and the diameter, I mean, it looks like this is probably just, the bed at its widest point is probably 4 or 5 feet deep from the sidewalk, and the sign on their drawings is showing starting at a height of 20 inches off the ground, from what we're seeing on this elevation that was submitted to us. So we're already seeing that the sign starts at 20 inches off the ground, and we're, you know, which is quite low.
I've just, on the history, Mr., you said that it was approved in 2009. This is, my recollection is, we might have improved this ground sign in 2009. I recall them trying to get wall signs many, many times, large wall signs for DaVita Dialysis. I remember, you know, joking around that dialysis didn't seem to be an impulse purchase. We didn't understand why it needed to be so big. Eventually, we did approve it after several tries. We approved something this year for this property, like in January of this year, didn't we? Maybe it was the wall sign or something?
No, there's a wall sign package. It was approved as referenced by Mr. Jacobs. It's a dark blue
Yeah.
background, non-illuminated
Mhm.
wall.
Yeah, and we approved something in January of this year for a
Right.
wall sign. So it's not that long ago. So they've been in, you know, what strikes me, they want to make it easier for clients, they say, to see the sign without turning their heads while driving. So the argument here seems to be one of safety, yet, you know, I'm hard pressed to find a reason to turn this sign around. I mean, this is an orthodontist and a dialysis place. So again, it's not a drive-by and pull in. You know, I mean, I understand, you know, some of the rationale, but I need to see more, because I agree, first of all, I agree, we can't have lights facing up on this. it seems like a big sign pretty close to the street, too. It's already within, and we have that 25-foot regulation for reasons. You know, I know that's been around a long time, and I know we have to vary it all, and we don't like to, we never wanted to really change that because it gives us a lot of discretion, whatever that reason being, but I'm hard-pressed to vote to approve this tonight without more information. Yeah, go ahead, Mr. Kennelly. You just have to borrow the microphone.
I think actually, what's really going on here is that this is sort of an extension of a concern that I guess the applicant had when it was looking for the very large wall signs, which is somehow, I think it's as more signage as advertising than it is as signage for clientele to find them. So you turn the sign to face Black Rock Turnpike, essentially, perhaps, as a way to make the ground sign more like advertising for the business practice. I mean, it may well be that they view it also as a way to stop drivers from turning their head, but that's probably at the heart of this. How do you make the business more noticeable? How do you let that be the case? That's one of the things we kept saying no to, unfortunately, with the size of the wall signs. So for all the other reasons mentioned by Commissioners Wagner, Alessi, and Jacobs, Suter, and yourself, Mr. Chairman, I think we probably have to reject this.
Yes, Commissioner. He said for all the reasons we stated, he thinks we should reject it. That's what he said. Right? Did I sum that up?
Yeah, I'm saying, but you see the
I go Mr. Jacobs and then Mr. Suter.
There's one other just thing to be brought up on that building. There's an illegal banner hanging on it right now.
Oh, yeah, right. Yeah.
Which just, you know, how do you put up an illegal banner and then come to us and say, well, we want to, you know, we want you to give us a lot of leeway here. You know, you don't put up an illegal banner and come to us. It just doesn't, not the way to do things. So.
Yeah, I'm waiting for Spooky Town to come back to us for something.
Yeah,
Oh, yeah, we went there. I was with somebody and I said, how is that legal? I said, well, it's not, but it should be down soon. 'Cause
I spoke with the manager
Uh-huh.
because I live right near there, and he said it was going to be coming down a couple days after Halloween. Well, it is more than a couple days after Halloween, and it's still hanging.
Yeah.
I'm waiting for a Christmas.
Anyway, Mr. Suter, you have questions, comments on this application? Sorry.
Yeah, I had forgotten about the fact we approved wall signs, and those should be sufficient for drivers and pedestrians to find the building, in addition to those who get close enough to see the ground sign. So I don't think they really need the turned around ground sign for that reason, and also because since it's very hard to determine exactly where it is on the plot plan, I think we should reject it too.
Thank you, Mr. Suter. Anyone else?
Yeah, I mean, I would
Yes,
just,
Mr. Wagner.
I would like to just put a fine point on that. I mean, it's not difficult to determine where it is on the plan. It's not possible because they didn't submit a plan showing where it would be located. And that makes it impossible for us to judge whether it impacts the sight lines or not. It looks to me as if it would clearly impact the sight lines negatively. So, you know, it's not difficult. It's impossible because they didn't submit a plan showing where it was going to be located.
Okay. Anyone else on this application? I think we've beaten this round enough. If nobody has any more comments, we have a motion to approve. Forget about what the conditions were. We have a motion to approve. Approve. It was made and seconded. Mr. Suter seconded it. Yeah, before Mr. Jacobs started the conditions. But let's just say we have a motion to approve. It's been made and seconded by Mr. Suter. For 427 Stilson Road, compliance application of J. Braun to modify and improve site plan. We need a 2/3 vote to approve it. All in favor signify by saying aye.
Aye. I retract that.
Retracted aye. We have no one in favor. Yeah, all opposed to the motion to approve say, what was the other one? Nay. Say nay. Nay. Okay, it's denied unanimously. The next item on our agenda is 1150 Post Road, compliance application of Paolo Vincenti for an overall sign plan in the Center Design District.
The proposal for this particular building is one single wall sign. It's 47 square feet, made of die-cut aluminum letters, stud mounted to the building. It will be combination of colors of brushed aluminum and green. It's it's not internally illuminated.
Okay. Do we have a motion?
Motion to
Somebody-
approve.
Second, Mr. Wagner moves to approve, and second by Commissioner Alessi. Any discussion on this one? It's a sign, so you should start, Mr. Jacobs.
My first question would be to staff on the square footage of the sign versus the building, and do we meet regulations?
Yeah, they could have up to 72 square feet.
And this
Proposal
is-
for 47.
Okay. Anyone else?
Appears to meet our regulations, and I would vote to approve.
Okay. And there's nothing special in the center design district that would prohibit this sign?
No, internal illumination is not permitted in the center design district.
No, but I think
And
we'd
no
like to see
illumination is proposed.
Yep. Okay. Anyone else? Anything, any further, any other comments? Okay, the motion's been made to approve and seconded. There's no further comments. I'll call for a vote on 1150 Post Road compliance application of Paolo Vincente for an overall sign plan. All in favor signify by saying aye.
Aye.
Aye. Opposed? No one's opposed, and it's approved unanimously. That is it for our executive session. We'll go to public hearing in a few minutes. We'll take a little break. At this time, though, I'd like to recognize we have 3 commissioners that chose not to run again. So this will be their last meeting with the commission. I've served with Mr. Jacobs for 8 years, almost always in this configuration or something like it. He's always been, kind of seated near me, and he's been an outstanding commissioner. Mr. Suter also, he's been a commissioner, I believe, for 6 years. And again, another privileged person I've been privileged to serve with. And finally, Commissioner Parker, who's been here for the last few years, who we're also going to miss tremendously. And we hope that she stays involved in town issues and town government, because she's been just a tremendous addition to this commission. We'll miss you. Just tell us what questions we failed to ask after you're gone, because we always relied on you to ask outstanding questions. Yes, Commissioner Jacobson.
I have totally enjoyed serving with all these commissioners, and I wish our commissioners that are leaving the best and thank them for their hard work.
Thank you. I think we have some treats and stuff for the commissioners, so we'll just take a little break, maybe start up in like 10 or 15 minutes. We don't really have to. Okay. This is the November 12th, 2013 public hearing of the Fairfield Town Plan and Zoning Commission. We have 2 items on our agenda tonight. The first item is a subdivision, 600 Hoydens Lane subdivision application of AFM properties for 2 lots in the AAA zone. We continued this matter from October 22nd, 2013. Mr. Fitzpatrick.
Mr. Chairman, members of the Commission, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Crane, Bologna. We have offices at 1735 Post Road. I'm here this evening representing the applicant, AFM Properties, LLC, the owner of the property located at 600 Hoydens Lane. The managing member of the owner, LLC, is Mary Wellner, a lifelong Fairfield resident. The Wellner family has owned this property for approximately 35 years. The property presently contains a single-family residence and is located on the northerly side of Hoydens Lane. This property is located in the residence AAA district, which, as you know, requires a minimum lot area of 2 acres. The property here contains 4.192 acres. Proposal here is to subdivide the property, retaining the existing single-family home, create a new conforming building lot. The proposed new lot, Lot B, will contain 2.133 acres with a net of 2.017 acres when the accessway is netted out. The lot fronting on Hoydens Lane, which includes the single-family home to be retained, will contain 2.059 acres. Both lots conform in all respects to the applicable regs, including lot area and square. At the last public hearing before the Commission, which was October 22nd, the Chair raised the issue of the ability of the property to accommodate the 10% open space dedication. I'd like to respond to this issue in two ways. First, an examination of state statute. I usually, quite frankly, pay more attention to our subdivision regs, but this one requires some research. An examination of state statute on this issue reminded me of the exception from the 10% requirement for family transfers. Since the Wellner family has owned this property for approximately 35 years and has no intent to sell, this is an appropriate provision of state statute for my client to utilize. I'd like to submit a packet of material and go through it with you.
Thank you. And Mr. Fitzpatrick, before you go, I just wanted to call your attention to one thing, because when it was brought up at the last hearing, the minutes, which is our record of September 10th, 2013, when we talked about this, the minutes state it was a consensus of the commission to hear the application first on the open space disposition. No action is required at this time. That was the same meeting where we, for the 2500 Hillside Road, recommended the open space. So just at the last meeting, I was just a little, concerned that we got to the very end that we had said in our minutes that we wanted to hear about that, and you were already going into summation and nobody had asked about that. That was the reason for my concern there.
Understood.
So I thought it would be part of the presentation, that's all.
Understood, Mr. Chairman.
Yep.
8-25 is that I've given you is the Connecticut General Statutes. In that section, if you go back to the portion that I've highlighted on page 461, you'll see that above the highlighted section, there's language vis-a-vis the calculation of the 10% fee in lieu. There is then a sentence which states, the open space requirements of this section shall not apply if the transfer of all land in a subdivision of less than 5 acres is to a parent, child, brother, sister, grandparent, grandchild, aunt, uncle, or first cousin for no consideration. That's the relevant part. That is what we're going to propose to do here. If you continue, I have also copy of your subdivision regulations, and section 2.3 is the open space section on page 13, and then if you continue on to page 16 at the bottom, exemptions, it states this section 2.3, which is the entirety of the open space section, shall not apply to, in relevant part, those subdivisions and transfers exempted by section 8-25 of the Connecticut General Statutes. You'll see that 8-25 is the first section I gave you. I have then given you, given you 3 documents relative to AFM. The first is an affidavit from Mary Wellner confirming that she's the managing member of AFM Properties LLC with a business address of 187 Maywood Road. That AFM has 2 members, Mary Wellner and her son Anthony Wellner. That AFM holds title to 600 Hoydens, and that AFM, upon approval of the subdivision of this property into 2 lots, will execute any and all documentation necessary to transfer the property to her daughter, Eileen Wellner. There is then an LLC resolution dated today, signed by Mary Wellner and Anthony Wellner as members of AFM Properties LLC, confirming that they will convey the property to Eileen Wellner as well. And then lastly, there's a copy of a quitclaim deed, proposed quitclaim deed, from AFM Properties LLC to Eileen M. Wellner, to be signed by the 2 members of the LLC with a legal description of the property. My point is that in this instance where this property is being conveyed from an LLC consisting of 2 members of the Wellner family to the daughter, that this property is exempted from the entirety of the open space requirement under both state statute and our subdivision regulations. It transfers to a daughter, which is cited in 8-25. It's a subdivision of less than 5 acres, transfers all of the subdivision, transfers for no consideration.
Where does it say about an LLC? A question for Mr. Fitzpatrick. Mr. Fitzpatrick, where you've highlighted for us the open space requirements of this section shall not apply if the transfer of all land in a subdivision of less than 5 parcels to a parent, child, brother, sister, grandparent, grandchild, aunt, uncle, first cousin for no consideration. Where is it from one LLC to another?
It's not. I think the purpose and intent of the regs is served where you've got a 2-member LLC, which are members of a family.
So in other words, highlighting this language is to highlight your belief about the purpose and intent, but it's nothing in here that 2 limited liability corporations exchanging.
It's not 2 limited liability.
By one in this case.
It's one to a daughter and a brother, a sister of the 2 members of the LLC.
Yeah, Mr. Wagner.
No, I mean, I appreciate it. It's creative. But so the section would seem to apply on a prospective basis, right? I mean, the affidavit
Yes,
and the quitclaim is from today. That didn't exist before.
correct.
You agree with me that an LLC doesn't have a parent? Well, I guess it could have a corporate parent.
I could have, Mr. Wagner,
Yeah.
done a deed today,
Yeah.
recorded it on the land records today, and had the property in the name of 2 individuals.
Then the application wouldn't be in the name of the individuals.
That's true.
Yeah. Do you know of any cases that are interpreting the language
I've
to
got to
your...
tell you, I found one case.
Yeah.
Actually, you might find it interesting. In this case, which is a Superior Court case from Reading, one argument was that the Conservation Commission failed to make an open space recommendation. Another argument was that it didn't comply with this section because the person who was going to gift the property retained one of the lots for himself rather than conveying all the land in the subdivision.
Mm-hmm.
Quote, the Conservation Commission determined that the Witten subdivision was exempt from the open space requirement of 8-25 because Witten was transferring the subdivided parcels to his sons. Honan does not dispute, that's the plaintiff, that the land sought to be subdivided was going to be transferred to Witten's children. Rather, his position is that since Witten intended to retain a portion of the land that is to be subdivided, the transfer does not consist of all land in the subdivision as required by 8-25. Notably, Honan has not identified any case law supporting his contention that all the land in a subdivision must be conveyed in order for it to be exempt from the open space requirements under 8-25, nor has this court's research revealed any cases so holding. Therefore, the Conservation Commission's interpretation to exempt Witten was not, as a matter of law, erroneous. If the land were to interpret 8-25 to require a landowner transfer every segment of land to a designated family member, no one could do what Witten attempts to do here, i.e. transfer a portion of the land to a family member while retaining the balance for himself. Nothing in the statute indicates that such transfers are prohibited, and no court has so held. Thus, the Conservation Commission's determination that Witten was exempt from the open space requirement of 8-25 was not erroneous. Clearly, an expanded interpretation of the language.
Right, and also would seem to imply that it's the subdivided land and not all of the subdivision that is necessary to be
That was
transferred.
this interpretation, you're correct.
Right, okay. But that doesn't, I mean, the land in the application in that case was held in the individual's name personally.
That's correct.
Yeah, and so you didn't find any cases that treated a
An
corporate
LLC
entity?
to be the equal of a person? I
Yeah,
did not.
Yeah. I suppose, I mean, there is also the sort of the general statutes that define a person in the law as including corporate entities, right?
SAC was arrested, so.
Yeah, but I mean, as a general proposition there, you'll agree with me, I mean, I don't have the citation offhand, but Connecticut General Statutes defines a person as including a corporate or organized entity, right?
I believe that's true.
Yeah, so, all right. Would this be a significant, is it significant that this application, due to the timing of the regulation changes, be processed in this way? In other words...
Absolutely.
Yeah. So if we were to find that the LLC didn't qualify, and therefore this prevented the subdivision, for you to then make the transfer and come back would be detrimental because it would fall under the new regulations.
Severely so.
Yeah.
You can, I was just gonna, I was gonna comment, but you can go ahead.
No, I just wanted to,
No,
on
yeah.
the same point. Just one, I'm not sure, I mean, this really isn't, we're dealing with the application, but I'm just wondering, going forward, if we were to follow your interpretation of the law, it would seem like this would be an invitation for family members to become involved in LLCs to allow them to take advantage of this particular exemption. I mean, I don't know, I mean, no, they wouldn't have to, but it just seems like this would, I don't know, I mean, it was...
I really don't think that in most instances, it would be any different than quitclaiming property to individuals if that indeed were the requirement. I was very surprised I found literally one case on this section of the regulation.
I'm actually a little surprised too, Mr. Fitzpatrick, because last time I think the question was just like, how can you, if you don't have enough land to give open space, what's the fee in lieu of what? I was just trying to question that. I thought you were going to present to me.
I will present that before we're gone tonight.
Cases about that. And again, if you're talking about precedent in this commission, we've all been on it a while, so I mean, I have, just from Mr. Went, from public record from Mr. Went, we look at this. I have every subdivision that we've approved for the last 17 years. I know which ones are in the AAA zone. We do. We know which ones we had recently. And I thought you were going to show me ones that were less than 4 acres where we've accepted a fee, where I actually found 5, but only 1 in the last 9 years.
I found 7, Mr. Chairman.
found 7.
I'll give them to you in the
Right,
next
so I
5
thought your
minutes.
argument was going to be that we've done this before. The argument now seems to be that it's exempt because it's transferring to a family member, which again, I think might open, so there's no fee at all, there's no open space at all. That's the new argument.
I'm giving you a 2-pronged analysis.
Okay.
One is, I believe the statutory provision covers the situation here and no fee is due. But in the event, as I term it, the extremely unlikely event, that the commission finds this statutory exemption does not apply,
Okay.
I'd now like to address the issue of the imposition of a fee in lieu of open space dedication in circumstances where the dedication of
You have a
open
question
space...
first, before he goes there, Mr. Fessardo, if it's on the previous...
You're moving away from the exemption?
That is my first argument,
Right.
Commissioner.
I'm
I'm ready to move away. If you'll
Yeah,
not
we probably
please-
should talk about more exemption things than now while we're on that.
Right.
Is that what you want
Okay.
to do?
Yeah,
Okay.
so I
Why don't
just-
we clear that first?
Just wanted to follow up. I mean, frankly, this is the first time we're all seeing this, right? So I'm just processing it, on the fly. But occurs to me another question. How long does the transfer have to have existed, or how long does it need to be for? In other words, we could have a situation where, all right, the LLC owns it, then they want to subdivide, they transfer it into a family member's name, they come in, they subdivide it to family members under the exemption, and then once everything's processed and done, then they simply transfer it back into an LLC, and so
Commissioner.
basically defeat the intent.
The language of the statute is the language of the statute.
is what
I've
it is.
worked in the legislature and
Yeah.
on the Judiciary Committee. Watching legislation It's like watching sausage being made. It's not a pretty sight. It's, oh, I'd really like to get this done. Can you write something that'll get that done? Okay, Senator, I'll give it a try. I was amazed to find no case law. There's nothing that says the person has to hold it for 2 days. They could transfer it in 2 days. I think you're absolutely right, but the statute's the statute.
Right. And so, flowing from that, your argument is that because the LLC is held by the family members themselves, we should disregard the corporate form?
That's the point I'm trying to make. And I think that clearly the beneficial owners of that LLC are 2 members of a family. They are looking to transfer it to another member of the family. That is the purpose and intent of 8-25. It's recognized as an exemption under our subdivision regs. That's my argument.
Okay.
Anybody else on the exemption issue? Or yes, Mr. Suter.
Regardless of whether the interest was transferred directly to the family member in their own personal name or to an entity that was owned by them, they would still have ownership of the land. So it seems to me that Mr. Fitzpatrick's argument has some validity.
Okay.
At this point, Mr. Chairman, I'd like to address the issue of, in the event the exemption argument is not successful, which I feel it should be, I'd like to address the issue of the imposition of a fee in lieu of open space dedication in circumstances where the dedication of open space cannot be accomplished. The fact of the matter is that in every matching set of circumstances, and I only looked in the AAA zone, that my research has uncovered, this commission has recognized the impossibility of imposing a dedication of land requirement and has imposed a fee in lieu of open space requirement. I'd like to submit a packet of documentation on this issue. While I'm up, Mr. Chairman, the issue came up last time about the fact that the inland wetland permit was in the name of MTW rather than the property owner LLC, which in this case is AFM. I am going to submit a letter addressed to me from Annette Jacobson of the Town of Fairfield Conservation Department. This letter is to confirm that the conditional approval dated August 2nd, 2013 regarding inland wetland permit 2012-13-11 is applicable to AFM Properties LLC.
Okay. That's okay, we can share here. Because our president be voting on this anyhow. Unless we do it tonight.
Flip this one across. The first packet of material that I've given you is Julie LeBlanc, Julie Bluer, and 400 Hulse Farm. This was my application. This is the map. You can see parcel B has a net acreage of 2.2. Parcel A has a net acreage of 2.093. Let's agree for our sake of our arguments that I need 4.4 to be able to satisfy the dedication. This clearly cannot. You can see my letter to the commission included actually the statement at the bottom of the first page, the only, that if we gave away the 10%, it would render the lots non-conforming. As a result, the only possible open space option is the imposition by the commission of a fee in lieu of the open space. That was my request. If you look to the second page in the packet, there's the Plan and Zoning Commission approval of a fee in lieu. It was actually a sad set of circumstances, so the fee in lieu was reduced to 5%. And then there's a copy of the assessor's short form email calculating the 10%. Again, unable to satisfy the dedication, the commission approves fee in lieu. Next is David Prusser at 3880 Reading Road, acreage of 2.04, acreage of 2.38. When you do
That
the-
actually had 4.42 on that one, so I didn't
Yeah,
count
but
that
when
one.
you take the 10% of 4.42, you're not going to be able to satisfy
Okay.
4.0.
That's, okay, that one I didn't include, okay.
This one, there's a letter from Mike Paterno of the Huntington Company requesting an offer of payment of a fee in lieu because it would not satisfy, and there's a copy elsewhere in here of an approval from the commission in paragraph 1 approving the fee in lieu, as well as a copy of the assessor's computation of the 10% figure. Next is Mackenzie on Merwin's. This is 2.0 and 2.03, clearly two rear lots. Clearly, they cannot satisfy the dedication, and the approval from the commission on the second page, they had asked for a waiver of the fee in lieu. That was denied, but the fee in lieu was imposed, and there's a calculation by the assessor of the fee in lieu, and then I actually include a copy of the agreement whereby they committed to pay the fee in lieu.
Sorry to interrupt you, Mr. Wagner has a question on something you just said.
So in each of these, the applicant is being transparent about the request in that if we had to make the dedication, we couldn't, and therefore our subdivision would not comply. I mean, from the ones you've just gone through,
Correct.
right? When you made the request for our referral earlier for the fee in lieu, did you have this in contemplation? Did you realize that you were asking for a fee in lieu because if you had to dedicate, you wouldn't make the requirement?
Absolutely. I didn't recite it, but I absolutely knew it. Otherwise, quite frankly, on the property to the rear, let me go to the base map, our map, Walt. This property here, it's two building lots, same family. And when I proposed that, and it abuts Bridgeport hydraulic property, we tried to dedicate. 10% is real money.
Yeah.
We didn't want to pay 10% money. We wanted to dedicate the land. We tried to dedicate the land, and your commission said, come on, get serious. There's no connection to anything. We don't want this. We don't want a strip of tiny little piece of land. Give us the money. So, quite frankly, it never occurred to me I'd have to be making this argument to persuade you to take the money.
Yeah.
So that I didn't recite the fact that we couldn't give the land, but I knew all along, obviously, we can't give the land. We're not, you just can't.
Yeah, no, and then I think then that's when Commissioner, Chairman Barrett's raised the issue of, well, then what if, right? You can't, can this substitute? Got it. All right, thank you.
Sure. Next is 185 Mine Hill Road. I did this one. This was Tom Nettleton's property. The net is 2.22 and 2.01, not enough to accommodate the 10%. In my letter, I noted that we cannot accommodate set aside of 10%, and the commission approved a 5% fee in lieu, and there's the assessor's computation as well. Next was Lewisburg, Townhouse Road. This is 2 acres and 2.004 and 2.09. Can't accommodate the 10%. There's a letter from the Huntington Company saying we cannot accommodate the 10% dedication. We request that the fee in lieu be waived. The commission approved the fee in lieu but reduced it to 5%. And there's the assessor's calculation as well. Then there's 2100 Burr Street on Hillside, Capital Appreciation Fund on Hillside. This is 2.2 and 2.003. This is mine as well, Tom Keegan. This cannot accommodate the dedication, So we asked for a fee in lieu. The commission approved the fee in lieu, and I have a copy of the agreement agreeing to pay the fee in lieu. Then there's property, which I think is the last one, on 2221 Cross Highway, a recent one. The two pieces are 2.002 and 2 acres even. Can't accommodate the 10% dedication. Through Mr. Jankowski, requested a fee in lieu. The commission approved the fee in lieu. There's an agreement that I attached, as well as a copy of the assessor's computations. In every case that I've been able to uncover, if there was not adequate land for an open space dedication at 10%, the Plan and Zoning Commission imposed a fee in lieu dedication. That's the same decision that I submit should be made here in the event the exemption argument is not accepted. I think the point of the open space requirement is not to eliminate the chance to subdivide one's property, but particularly in this instance, to mandate that a 10% fee be paid to be lumped with other 10% fees and purchase meaningful open space in the town of Fairfield. Past precedent, regardless of the commission's makeup, is an important element of the decision. The courts make mention of the fact that weight must be given, quote, to the board's consistent interpretation of the regulations over the years. That's the Doyen versus ZBA case, 67 Connecticut Appellate 597, a 2002 case. The actions of this commission have been consistent, should be followed here. Also, there's no historic value to the home at 600 Hoydens, despite its original age. The home is not in the Fairfield Historic District, is not on the State Register of Historic Places, is not on the Federal Registry of Historic Places, and in the 1960s it was dramatically or extensively remodeled, adding a first-floor family room, adding a second-floor master bedroom suite, adding an additional staircase, and removing walls in order to make the rooms larger. The historic value of the home, if it ever existed, certainly no longer existed. I've given you the conservation approval, conservation letter confirming that approval applies to the applicant here. For the reasons I've outlined, I'd request this application be approved. Mr. Walter Jobst is here with me. I'm a surveyor and engineer on this project. We'd be happy to answer any questions the commission may have.
Yeah, I just have one more comment, because again, this evidence that you submitted is all actions of what you referred to as this commission. Again, this commission is the body, the Town Plan and Zoning Commission. What led me to question this is, I mean, even in the cases you've submitted, and I look back at our own records too, we have them as well. I found all these transfers that you cited where the fee and exactly what the fee was. Only one of them's happened in the last 9 years. When you say this commission, there aren't any commissioners here that have seen that, except for the Anvil property, which you're right is in 2012. That was fairly recent, where that was a strict 4-acre split, and it never came up on that particular one. I can't remember why. I don't know what was presented to us. I know, as Mr. Wagner said, some of these letters right out says we cannot provide this, and therefore we want to do that. And I was just, reading your letter, and that was my question, in lieu of what? And so I'm not disputing this evidence. This is all actions by what you referred to as this commission. I just point out that these commissioners were not on this commission at the time.
That makes the precedent no less valid, Mr. Chairman, I would just point out.
Yeah, I understand. Any other questions for the applicant here?
Well, I do.
Yeah, go ahead.
Doesn't matter if you mind. I'm sorry.
Well, you got him up here.
Well,
Better now than later.
just want, just so I can understand though, Mr. Fitzpatrick, let's assume, the elected zoning boards, plan and zoning boards in the state of Connecticut, routinely change hands between parties or factions that are somewhat more pro or anti-development. Is it your contention that a jurist looking at this would say that it should, say, a town Plan and Zoning Commission change hands in terms of the elected officials over, say, a 2 or 4 year period, and look to reverse particular policies or actions taken by past commissions, that somehow that would be violative of this doctrine that precedent must be or should be appropriately followed?
My point.
I'm just asking you.
My point.
I mean, I see as though
is more that if there is a consistent practice in an interpretation of a regulation, regardless of the turnover in commission, regardless of what party controls, and quite frankly, I pay no attention, and I think this board's to be commended. I don't think it's a party.
Oh, I wasn't
board.
saying just strictly
And
on
I think
party
that's
lines.
a
I'm talking about
very
just in terms of
positive thing.
philosophy.
But regardless of the change, if there's a consistent interpretation of a regulation, I think any judge would find that to be a valid precedent. In this case, I can't find one to the contrary, one action of any town plan and zoning commission in 4A in a residence AAA zone.
Right, yeah, what I couldn't find either is were there any applications that were denied because of this that wouldn't be on my list of approved subdivisions, so I could not find that, that wouldn't be there, I just have the approved one, so. But yeah, I'm not disputing this list, it's consistent with our records, I was just, pointing out that there was only one in the last 9 years, and as Mr. Kennelly said, and with precedent aside, if we, I don't want to talk about this case, if a decision is made, are we bound by that decision if we don't believe it? Regardless of why, if we believe our regulations weren't interpreted correctly, but that's for us to decide. Is there anything further for the applicant here? No, well then I will close this public hearing.
Thank you.
Before you start the next one, can you
Yeah.
see if Sally wants to leave?
Yeah, sure, yeah, okay, yep, check out. Yeah, we'll take a minute to just get set for the next one.
Do you want to go?
You want to stick in the audience for this one?
Because I'll take you and then I'll come back to get Pat.
Okay, the next item on our agenda is 893 Sasko Hill Road, re-subdivision application of Bernard and Cynthia McDonald for 2 lots in a AAA zone. Mr. Fitzpatrick.
Mr.
Chairman.
Chairman, before we continue, open the hearing, I just have to state for the record that I'm recusing myself from this matter.
Thank you, Mr. Suter. And Commissioner Parker and Commissioner Jacobs have left, so you're left with the 6 of us, Mr. Fitzpatrick.
I'm very pleased. Mr. Chairman, members of the commission, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Frey, and Bologna. Office is at 1735 Post Road. I'm here tonight representing the applicants Bernard and Cindy McDonald, owners of property at 893 Sasko Hill Road. This property presently includes an existing single-family home, which has been approved in the past for 2 additional attached apartments. Property also includes a separate building, originally an onion barn, which has been utilized in the past as 2 apartments as well. This property is located on the easterly side of Sasko Hill Road, contains 4.57 acres. Property is located in the Residence AAA zoning district. Zoning regulations require a minimum lot area of 2 acres for the Residence AAA zone, as well as the accommodation of a 200-foot square. Proposal here is to re-subdivide the property into 2 lots. Proposed lot 1 will contain 2.57 acres. Proposed lot 2 will contain 2 acres, both satisfying the minimum lot area requirement. In addition, the proposed lots accommodate the required 200-foot square. This proposal was originally the subject of a re-subdivision application earlier this year, which was denied by the commission for 2 specific reasons. I'd like to quote from the Plan and Zoning letter dated April 15, 2013. The 2 reasons for denial were stated as follows. 1, the proposed plan does not comply with Section 2.7 of the zoning regulations in that more than one dwelling will be served by a single access to a rear lot, and such access does not provide a safe and practical means of access to the lot. And 2, the plan does not comply with Section 2.1.1.6 of the subdivision regulations, and that the access way will be serving more than a single interior lot. End quote. Before proceeding further, Mr. Chairman, I would request that the record of that application be made part of the record of this application.
Okay.
Thank you. I also would like to submit, this is a regulatory analysis I did and submitted at the last hearing. Very same as the last hearing. But I realized it had not made it part of this record, and I'd like to submit it to its rules.
Okay. I mean, but the plans here for this application, we have them all here in front of us.
Yes.
I remember this. Was this submitted last time too as well, or something like this was submitted last time?
the very same.
This is very same, yeah, I remember this document as well, okay.
I should first note, the Connecticut case law makes it clear that if a second application addresses the reasons for denial set forth by the commission in response to an earlier application, then the subsequent application should be approved by the commission. I submit here that the record before this commission on this application will fully address the perceived shortcomings on the first application. The commission will hear from Mr. Michael Baturla, a registered land surveyor and PE with the Huntington Company, as well as Mr. Michael Galante of Frederick P. Clark and Associates, a traffic engineering firm, and I will conclude the presentation. I will, as usual, request the right to close this public hearing process with my rebuttal. Before introducing Mr. Baturla, I'd like to reiterate for the benefit of the commission some facts about this parcel of property. This is an interesting parcel where the Onion Barn was originally constructed perhaps in 1926. The original Onion Barn was just that. Sasko Hill Point was all onion fields. And that Onion Barn was converted into residential living area at the time the three-story main residence was constructed approximately 1 year later. The conversion of the Onion Barn into a residence was done so the owners had a place to live while the main home was under construction a short distance away. Both the Onion Barn and the main home have been subject of significant renovations by my clients, including new plumbing, heating, kitchen, baths, etc. A slate roof has been reinstalled on the main building. It is my client's intention that the existing apartment located to the west of the main residence be removed. The accessory apartment, which exists on the easterly side of the building, may be retained. In addition, after discussion with the zoning department, my clients have agreed to limit the use of the Onion Barn residential dwelling to one rental unit. The end result is that where there are 5 living spaces today, the original house plus 2 apartments, plus the Onion Barn with 2 apartments, if this application is approved, there will be a maximum of 4 residential units, a reduction consisting of the main home, possible accessory apartment, the Onion Barn residential building, and the new home. At this point, I'd like to introduce Mr. Michael Baturla, registered land surveyor and professional engineer with the Huntington Company, who prepared the plans and will describe them for the benefit of the commission. Michael.
Mr. Chairman, members of the commission, as Mr. Fitzpatrick said, I'm a licensed land surveyor, licensed professional engineer here in the state of Connecticut, member of the Huntington Company. Subject property consists of a piece of about 4.6 acres in size. The main building is about mid-lot, and the outbuilding is on the northeast corner. On the property, there exists a 20-foot strip that goes back with a piece of property in the back, and we know it from last meeting as the charred property. Our intent is to take the piece of property and split out a 2-acre piece out in front. As Mr. Fitzpatrick said, it'll have conforming road frontage, conforming square, same thing with the back lot. Site plan shows a proposed house on the newly formed lot in front. I had soil tests done, witnessed by the health department, and I could fit a state-conforming septic system on it. Also have a stormwater system. I submitted computations which were reviewed by the engineering department, Laura Pooley, who also agrees with me that there'll be no increase in stormwater runoff for all storms from the 2 to the 100-year storm. But we also propose on this plan that's before you this evening is to improve the existing access driveway. What we'll do is down the existing right-of-way line, we'll have two 10-foot driveways with a middle median strip of 2 feet, and that'll be a Belgian block median. That'll give us a full paved width of 22 feet. What we'll also do on the north-south driveway is improve that to at least 10 feet. Again, the main access way is up here on the north side. We'll make some improvements to the turning radius on the driveway behind the onion barn. And if we look at a detail I prepared on the third sheet, it shows that truck traffic will be able to make a proper turn to get to the house that was built back in '86 on the charred property. The houses are served by public water, and I think Attorney Fitzpatrick will be submitting letters from both different commissions in town that says that the turning movements for trucks will be adequate. Questions?
Questions for Mr. Paterlo? Yes, Commissioner Jacobs.
I noticed on Ms. Cooley's report about a patio, you're not planning on putting on any patio?
No, what she mentioned, I wanted to show a pool, because most people have pools, and I just show a pool behind the proposed house. She mentioned in her letter, I think it was back in January, if a pool patio were added, that I would have to increase the stormwater, but that's always the case. But that's what she meant. I think she also said if it's over 200 feet, 200 square feet, and that's just standard in town anyway. Any additional impervious area of 200 feet, it needs to be addressed.
I also have a question about the trees, but I guess, are you the person?
There are two big maple trees that she suggests that we take down.
Okay.
That's in the new turning radius.
The tree commissioner said the tree warden said to submit a plan on the tree removals, or?
Again, I don't know for a fact, but I think he probably meant anything along the shoulder in Sasko Hill Road.
And you're not planning on removing any of those?
No.
Okay.
But that's common though anyway. Anytime, even brush, if we were going to, cut the brush out in the shoulder of the road, since it's town right away, we would have to get we always get the tree warden involved.
Okay, thank you.
Thank you, Michael. At this point, Mr. Chairman, I'd like to introduce Mr. Michael Galante of the traffic engineering firm of Frederick P. Clark and Associates. Michael?
Good evening, Mike Galante, Frederick Clark Associates, Traffic Consultants, and we are located in Fairfield also. My sole purpose in this application was really to look at the location of the proposed driveway and determine if it has the appropriate and adequate and required stopping site distance for a residential driveway. In doing that, there are a couple steps we need to take. It's a combination of what we do at Clark Associates and what Huntington does for us as far as measuring and developing profiles, and I'll touch on all of those in 2 minutes or so. Our first step was to actually measure the speed of traffic traveling on Sasko Hill Road near the site frontage in the vicinity of where the driveway is going in. That is done with the hose across the road. We put it out there for several days. We measure the speed over a period of time, and we identify what we call the 85th percentile speed of motors traveling. It's a standard the town uses, and it's certainly a standard the Connecticut Department of Transportation uses. We determined that the northbound speed was 31 miles per hour at that location, and the southbound speed was 34 miles per hour. I'm looking at figure 1, by the way, which shows hourly volumes, and it also obtains speed. Just for reference purposes, the graph you're looking at shows the volume, And it's interesting, the peak volume occurs between 11 a.m. and noon on a weekday. It's not your typical commuter traffic. In this case, it's purposely done during the summer, and it actually picked up the traffic going towards the beach at the end of the road itself, the town beach, or even the clubs along the road itself. And just, again, the reference was about 1,200 vehicles per day, and the peak volume, just for reference again, was a high of 112 vehicles. The rest of the day, the volumes are much, much lower. In our analysis, we used the 34 miles per hour in each direction to be conservative, if you will, in one of the locations, in one of the directions. The next step is to Huntington develop profiles of the road itself, Sasko Hill Road along the frontage, to measure the grade change, which is part of the analysis to determine stopping sight distance. Stopping sight distance is based on the speed of the motorist and the change in grades. That's okay. I've been drowned out before. And that combination put into a formula determines the speed, determines the distance we need. For example, the measured distance that we can see, and stopping sight distance is measured from an eye height of 3.5 feet, if you're traveling on Sasko Hill Road in this case, towards the proposed driveway, to an object that's 2 feet above grade. That's stopping sight distance. So it's a little different than intersection sight distance, which is measurement of commercial driveways and intersections and so on. The measurements provided by Huntington for northbound movement show we had 340 feet approaching that new driveway location. We have 300 feet in the southerly or the southbound direction. Based on the speed of 34 miles per hour and based on the grade change, which was around 2.5%, either plus or minus depending on direction, and the criteria used by Connecticut Department of Transportation and certainly used by the town, we need for northbound traffic 228 feet, and I'm looking at this part of the chart, as far as stopping sight distance. So if I'm pulling out of this driveway and you're driving northbound from the beach area and you see me and you need to stop, you would need 228 feet to do so. And we have 340 feet. So we certainly have the adequate stopping sight distance for northbound movements. Southbound, we need 245 feet of distance, and we have 300 feet. So in each case, each direction, we have the requirement of adequate stopping sight distance. We also provided the existing driveway just for reference purposes and comparison. We have 450 feet for the existing driveway. This is northbound, 500 feet southbound as far as available stopping sight distance. And we need 228 feet northbound, 239 feet southbound. Again, the existing driveway meets the standards that the town uses. That's a summary of what we've done as far as stopping sight distance criteria need, and it meets the standards that this town follows. And I can certainly answer any questions you have now or later.
Questions for Mr. Galante?
No?
Thank you.
Thank you, Mr. Galante.
Thank you, Michael. Mr. Chairman, I'd now like to take the commission through the folders that I submitted earlier. My intent was not to burden the commission with undue paperwork, but rather to fully describe the nature of this property and the specific changes to the application that have been made to address the reasons for denial set forth by the commission. What I'd like to do is to take the commission quickly as I can through the various folders and then analyze the reason for denial set forth by the commission relative to the first application. The yellow folder entitled ZBA Confirmation of Legality of Second Dwelling is just that. The opponents to this application, through Attorney Green, requested an opinion or a decision, if you will, from the Plan and Zoning staff regarding the legal status of the Onion Barn. As you will see from Mr. Devanchik's letter dated July 8, 2013 in this folder, he confirmed to Attorney Green that the staff finds no zoning violations on site, including the specific utilization of the Onion Barn as a single residential unit. Attorney Green appealed that decision to the Fairfield Zoning Board of Appeals. The Zoning Board of Appeals held a hearing on the opponent's petition to overturn and reverse the decision of the zoning administrator on October 18th, 2013. That application was unanimously denied. Also included in the yellow folder are some items of documentation which were submitted by the McDonald's at that hearing, specifically a colored photo and a property description for marketing purposes at the time the property was on the market. You'll note on the second page it includes specific mention of 3 kitchens in the main building, conferring the fact that there were 2 apartments plus the residence. If you go to the third page, there's specific reference to the Onion Barn and the fact that it's divided into 2 income-producing apartments, each with 2 bedrooms, 2 baths, decks. Further, there's a field card for the main house, which references an in-law apartment, as well as a field card for the Onion Barn, which references occupancy as 2 units. There's also a copy of a certificate of occupancy for the guest house, as well as a certificate of rental occupancy for the east wing of the main house, a certificate of rental occupancy for the east wing of the guest house, and a certificate of rental occupancy for the west wing of the guest house. Lastly, there are 2 real estate data sheets which reference the sale and which in the underlined portion confirm that the 4 apartments on this property produced $73,000 yearly income, as they put it, for this one-of-a-kind property. My point in bringing this to the Commission and to the ZBA in no small part was to convey to the Board and to this Commission that clearly there was general knowledge of the way this property was being utilized. My clients have been portrayed as greedy owners, perhaps looking to put something over on the town. This is not some stealthy sleight of hand. These apartments, 2 in the main house and 2 in the Onion Barn, were advertised as a specific attribute of this parcel of property. They weren't hidden. They were put in the material which was put on the street to help sell the home. These are not secret apartments. They were approved by the town. Zoning Board of Appeals evaluated this information, as well as the application of the opposition to overturn Mr. Devanchik's decision, unanimously rejected the application to reverse the zoning administrator. A copy of that decision is in the yellow folder as well. If you look at the manila folder entitled Chard-875 Sasko Hill Road, confirmation of legality of second dwelling, that is a fair description of what is found in that packet. Again, Attorney Green, on behalf of the opponents, sought to obtain a decision in writing from the zoning administrator as to the status of the charred property. His argument was that for various reasons, the 2 dwellings on the charred property were in some manner illegal. Primary argument was that the charred variance approving 2 dwellings on the lot was granted conditionally for 5 years, had been recertified in 1992 for 5 years, had not been recertified since, and was personal to the Chards. You'll find a letter in this folder from Attorney Fallon representing the Chards to the town attorney outlining the law on this issue of validity of the recertification conditions, pointing out specifically the Gangemi case, which is a Fairfield case, and the Garibaldi case in Norwalk, which confirmed that once a variance is granted with respect to a particular parcel, it benefited all subsequent owners thereof. Further case law confirmed that a condition limiting a variance to the current owners is severable from the variances originally approved. Bottom line is that those conditions are simply invalid. The town attorney, Attorney Lesser, in his letter to the zoning department, states that Attorney Fallon is correct in stating that conditions limiting a variance to current owners are not legal and are severable from the variance itself. Further, the variances for 875 Sasko Hill Road are not subject to the requirement that it be recertified every 5 years. The town attorney's letter specifically states, I believe it is proper, this is to the zoning department, I believe that it is proper for you to release the condition so that the variance will henceforth run with the land and not be subject to any time limitations, end quote. Attorney Green received this letter from Mr. Devanchik. That letter is dated August 22nd, 2013. He had by statute a 30-day period within which to appeal Mr. Devanchik's decision to the Zoning Board of Appeals, just as he had done with the McDonald's. Relative to Mr. Devanchik's opinion on the Onion Barn, he has not done so. Therefore, there can be no question, based upon the zoning department's letter, as well as the letter of the town attorney, that the two dwellings on the charred property are legal, and that the conditions on the variance which approve the two dwellings are invalid. The red folder, entitled Emergency Equipment Access, includes a copy of the letter denial for the earlier application from your commission, including the fact that the access does not provide a safe and practical means of access to the lot. At my request, the Fairfield Fire Department inspected the properties at both 893 Sasko Hill Road and 875 Sasko Hill Road with emergency response apparatus, and the fire department has produced a letter dated October 3rd, 2013, confirming they brought equipment onto the property, including the largest emergency vehicle in town, a 100-foot aerial ladder, as well as the AMR ambulance, and they were able to gain admission to the properties, as the letter puts it, without any problems. This letter is signed by Richard Fellner, the chief of the Fairfield Fire Department. Also included are photographs of the fire apparatus on the property. Lastly, a picture is included of the entryway to the McDonald property, including the stone pillars and the lights on top. The reason for this submission is to confirm for the commission just what those pillars look like. Clearly, they're in a good state of repair. The McDonald's have had them repointed, etc. Very attractive. And to confirm the fact that clearly two cars can pass one another without any difficulty at that entrance. Please keep in mind that if the commission deems it necessary to remove those pillars to comply with the regulations as you interpret them, my clients will remove them. I think the removal of the pillars is unnecessary and that they've existed for decades, provide an attractive entrance to the property, but my clients will agree to remove the pillars if the P&Z deems it necessary to comply with the relevant regulations. The green folder, entitled Rear Lots, Sasko Hill Road et al., consists of confirmation of approval for various rear lots on Sasko Hill Road and elsewhere in town. The first packet relates to property at 301-311 and 369 Sasko Hill Road, where three separate dwellings. Actually, the property at 369 has a cottage, so there are four separate dwellings with one driveway, 12 feet in width. As a matter of comparison, the driveway at the pillars at the McDonald property is 15 feet in width. This is a similar property, similar in that it's located on Sasko Hill Road, but with a much more intense use, and that this property uses but one smaller than 15-foot driveway. Also included is an aerial shot or an overhead showing the various buildings on the property, as well as the re-subdivision map found on the land records, which confirms the legality of the four separate parcels, three of which are rear lots. Also included are field cards for each property, again confirming the legal status of four separate dwellings being accessed by one driveway from Sasko Hill Road. Also in this packet is another Sasko Hill Road approval, in this case for a two-lot subdivision at 1111 Sasko Hill Road. This subdivision includes a rear lot, and that the lot adjacent to Long Island Sound does not have frontage on a public street. Also in this packet are the field cards for the two separate residences, as well as a site plan showing the original property, and then showing the property with the subdivision in place, construction of a new home on the rear lot adjacent to Long Island Sound. Also included is a site plan, as well as a copy of the assessor's map, again for property known as 775 Sasko Hill, which includes a rear lot accessed by an easement across the lot fronting on Sasko Hill. The point to be made relative to these Sasko Hill Road examples is that rear lots on Sasko Hill Road are not new and unusual, but rather exist in many locations. It should be noted that the Herbert re-subdivision, which was 1111, was as recent as 2005. There's one point I'd like to address. and that is the Commission's mentioned on several occasions of the fact that many of these precedents cited by the applicants were made by prior plan and zoning commissions and not commissions on which the members here sat. Well, that's true, but I would submit it's not relevant. The fact of the matter is, you're an elected board, people sitting in your seats change. That doesn't affect or negate the validity of the decisions made by your commission, albeit consisting of different people, but utilizing primarily the same regulations in the same set of circumstances. You're a commission of law created by statute. You've got regulations that you're bound to apply. What an earlier commission did utilizing the same regulations is relevant and is a precedent for your consideration. I certainly understand the frustration of the commission on occasion if you disagree with the application of the regulation in prior instances, but the fact of the matter is the better way to deal with that frustration is to change the regulations themselves. That's just what you've done by and large with respect to rear lots. Validity of that regulation changes under appeal. The court will make a decision. My point is that case law confirms applicants are entitled to rely on earlier decisions and expect a similar result under similar circumstances. How else could people invest their money in property, plan for their future, know whether they'll be able to subdivide their property for a son and daughter to build their home? As I cited for you earlier tonight, the case of Doyen, D-O-Y-E-N versus ZBA, 67 Connecticut Appellate 597, a 2002 case, states that weight must be given, quote, to the board's consistent interpretation of the regulations over the years, end quote. Also in the green folder, you'll find other rear lot approvals. You'll see one for Julie LeBlanc for 400 Hills Farm Road. You'll see the Duck Farm Road subdivision, which has many, many lots utilizing common driveways to rear lots. Of particular interest is the Duck Farm approval dated October 24, 1996, including the fact that the Commission's decision mandated in condition of approval number 6 that 3 lots, 16, 17, and 18, shall have a common driveway to Hulls Farm Road to reduce traffic conflicts on that road. Again, the point here is that there are many rear lots in town, and that in certain cases the P&Z is required specifically that a common driveway be utilized. In this case, that common driveway argument is now moot because the applicant here is proposing 2 driveways, each located in its own 20-foot access way. There's another rear lot plan in the green folder of Jeff Tallman on Cedar Road, as well as a rear lot with a common driveway on Woodhouse Road. Again, 2 lots utilizing 1 driveway. My point is there are rear lots all over Fairfield. The blue folder is entitled Sasko Hill Homes with Second Dwelling on a Single Family Lot. There's a list of and evidence of, including assessor's field cards included in this packet, setting forth many Sasko Hill Road homes with additional cottages on their property. Sometimes they're garage apartments, sometimes they're bungalows. The point is not to make any argument as to the legality or illegality of these cottages, but to simply point out that they exist and on Sasko Hill Road are very, very prevalent. I've also enclosed a folder entitled 10% Open Space Fee. Included in this packet is my letter to the Chairman of the Commission dated August 16, 2012, requesting a payment of a fee in lieu of the dedication of open space. I specifically noted that this property fails to satisfy the open space objectives set forth in section 2.3.1 of the subdivision regulations. Outlined that argument in my letter. Most importantly, this property does not abut existing open space, does not contain unique natural resources, wetland, streams, marshes, etc. The folder also contains the memorandum prepared by Ed Jones of the Conservation Department, dated August 12, 2012, in which he notes that the small size and isolation of any potential open space would not serve the public at large in any significant way. His letter states, quote, the staff concurs with Attorney Fitzpatrick's analysis and recommendation that a fee in lieu of the property would be appropriate in this instance, end quote. Plan and Zoning Commission, with this material in hand, in Tuesday, October 23rd, 2012, voted to recommend a payment of a fee in lieu for the subdivision of this property. This is a situation where, because of the access ways being deducted from lot area, that this property could not satisfy the dedication as well. Lastly, there's a memo from Don Ross relative to the calculation of the open space fee. Lastly, there's a large manila envelope with home and onion barn photos. The 8.5 by 11 is the onion barn building today. There are historic photos which show the onion barn as an onion barn, then the renovation into a residential dwelling in 1927. You can see pictures of the new home going up starting in December 1926. Final sheet shows the completed renovation of the onion barn into a residential dwelling in May and June 1927. Purpose of this submission is primarily for confirmation of the age and origin of the properties in question. I think I mentioned at the prior public hearing, there were several developers looking at this piece of property who were prepared to tear down the existing dwelling, subdivide the property, and create 2 new single-family homes. The actions of the applicants in preserving and restoring the main home should be commended rather than denigrated. Mr. Chairman, for the record, I'd like to outline the legal test for the Commission's evaluation of a subdivision application. The Town Plan and Zoning Commission acts in an administrative capacity in exercising its function in approving or disproving a subdivision application, citing the Reed case, Reed v. Plan and Zoning Commission, 208 Connecticut 431, a 1988 case, as well as Weatherly versus Town Plan and Zoning Commission, 23 Connecticut Appellate 115, a 1990 case. The Commission is controlled by the applicable regulations in reviewing subdivision applications. That's Town of Westport versus City of Norwalk, 167 Connecticut 151, a 1974 case. Quote, because a commission is not a court of law, its authority is stringently limited. It can only apply its regulations to the proposals which appear before it. It cannot make law. Again, the Weatherly case, 23 Connecticut Appellate 115. Lastly, the case of Garrison versus Planning Board of the City of Stamford, 66 Connecticut Appellate 317, a 2001 case, which states, quote, at the outset, we note that the Commission acted in its administrative capacity. As such, it has no discretion or choice but to approve a subdivision if it conforms to the regulations adopted for its guidance. I submit that this application conforms in all respects to the relevant zoning regulations as well as the relevant subdivision regulations. The minimum lot area requirements are satisfied, the minimum square requirements are met, setback requirements are satisfied, there's absolutely no road construction proposed. Conservation has reviewed this application, found no wetlands or regulated area on site. As such, no conservation approval is necessary. The proposed drainage plan, as you've heard from Mr. Peturla, has been reviewed and approved by the Town Engineering Department. Lastly, the sightline analysis prepared by Mr. Peturla, as confirmed by Mr. Galante's testimony, satisfies the criteria utilized by the Town Engineering Department. Property is served by public water and utilities, sanitary sewer. You have in your evidence from the Conservation Commission the letter confirming that a fee in lieu of dedication of open space was appropriate. Your commission has recommended that the applicant pay a fee in lieu of open space. The subdivision regulations state that the fee in lieu payment shall be equal to or not more than 10% of the market value of the property. Your file includes the assessor's calculations on this issue. For the point of reference, I'm going to submit copies of the very same deeds and approvals relative to subdivisions which cannot accommodate the dedication of the open space. I'll do so at that conclusion. I would like to now specifically address the reasons for denial set forth by the commission in its earlier decision.
Mr. Vitt, can I just, you're going to submit the same documents, more copies of the exact same
I'm
documents you
sorry.
submitted to the...
I'm going to submit copies of what I gave to you on the earlier application tonight.
The ones we have copies of already, you mean?
Yes.
Okay. Just through different records,
Separate
different
hearing,
applications.
exactly, separate hearing. I
Same
have.
night. Okay, that's fine. I understand. You don't have to review them again with us, though.
That's,
Okay,
yes,
thank you.
yes.
Those
I will,
seven,
I will do so if you'd like.
those seven historical applications.
Correct.
Okay, I got it.
At this point, I'd like to discuss the reasons for denial from your earlier decision that is outlined in your red folder. The first reason for denial is in relevant part is that the proposed plan does not comply with section 2.7 of the zoning regulations in that more than one dwelling will be served by a single access to a rear lot. That is no longer the case. The plan submitted here has been revised to provide a separate access and separate driveway to each rear lot. The Chard property has a separate driveway, and the McDonald property has a separate driveway. Fact of the matter is that more than one dwelling will be served by a single driveway. But the Zoning Board of Appeals has determined, relative to the McDonald property, that the two dwellings on one lot on the McDonald property is entirely legal. That decision has been appealed to the Superior Court by the opponents, but the applicable state of affairs at this point in time is that the Zoning Department has decided that two dwellings on one lot from 1927 forward is legal, and the Zoning Board of Appeals has unanimously upheld that decision. Similarly, the Zoning Department and the town attorney have agreed that the Chard property legally has two dwellings on one lot, and that the two conditions of approval on the variance approving the two dwellings are illegal and void. The end result is that there is a single access way and single driveway serving two legal dwellings on the Chard property, and a single legal access and driveway serving the two legal dwellings on the McDonald property. As such, the first part of reason for denial number one, I submit, has been fully addressed. In addition, reason for denial number one also states such access does not provide a safe and practical means of access to the lot. I'd like to make two specific points on this issue. First, the fire department, which was cited in discussion on this issue by this commission. I believe it was an executive session where it was stated, we can't be sure that a fire truck can get in and out of there. Well, the fire department has confirmed that they have brought their apparatus on the property. They are able to get in and out of this property, and have specifically stated that the existing driveway provides a safe means of access to the dwellings on the properties. Lastly, I just note that the existing driveway has been utilized for approximately 85 years without any incident that the applicants have been able to unearth. In short, I think there's no question that the driveways proposed do provide a safe and practical means of access to the lots. The second reason for denial in the April 15, 2013 letter of denial is that the plan does not comply with 2.1.1.6 of the zoning regulations, in that the access way will be serving more than a single interior lot. The revised plan that has been submitted proposes a separate driveway and a separate specific access way leading to each of the two properties. Again, the Chard easement includes a 10-foot wide driveway, and the McDonald property includes a 10-foot wide driveway. Since there are separate access ways to separate interior lots, I submit that reason for denial number two has been fully addressed. I submit that the applicant has successfully addressed the reasons for denial, and since those reasons for denial have been fully addressed, this application should be approved. My clients are entitled to the legally permitted use of their property. This application conforms to the relevant regulations and is worthy of your approval. For the reasons I've outlined, I request this application be approved. Mr. Peterla, Mr. Galante, and I are here. We'd be happy to answer any questions the commission may have. I reserve my right, as always, for rebuttal.
Any more questions for the applicant tonight while he's up there?
presentation?
Thank you for color coordinating the papers.
Yeah, that was a
That
huge
was very
help. Thank
helpful.
you. Okay. Well, the applicants concluded the presentation, and now we open the hearing up to public comment. The public will have a chance to comment. You can speak in favor or of an opposition to the application, just ask questions. I think Mr. Green will probably want to speak, but, any member of the public here that wishes to speak will speak. Once public comment is done, we go back to the applicant for a rebuttal, and he gets the last word. That's the way our rules work. So would anybody wish to be heard, any member of the public wish to be heard on this application? Mr. Green?
Good evening, Mr. Chairman, members of the commission, staff. My name is Joel Green. I live in Fairfield, and I practice law in Bridgeport with the law offices of Green and Gross. It's my pleasure to appear before you this evening on behalf of the Sasko Hill Neighborhood Association. The purpose of that association is the improvement, protection, and preservation of the historic character and beauty of the Sasko Hill neighborhood. The Sasko Hill neighborhood includes a number of streets, including Sasko Hill Road, Overhill Road, Penfield Place, Southfield Road, Northfield Road, Tide Mill Terrace, Harbor Road, and Sasko Hill Terrace. In addition, I appear before you this evening on behalf of Jeffrey Rubin, specifically of 847 Sasko Hill Road, and that property abuts the subject property of the application this evening. Originally, and I note that Attorney Fitzpatrick spent a lot of time talking about the original application, and the origin of the initial concern by my clients regarding this application arose out of the fact that they became aware of this subdivision application, and folks such as Mr. Rubin noted that there was this driveway that seemed to be heavily used, and he said it was used at all times of the night and day, and as this began to unfold through the initial subdivision application, we became aware that there were 8 separate dwelling units using a single driveway, serving as it unfolded the property that's the subject of this application, with a total of 5 dwelling units and 2 on the charred property. And it was illegal, and the property, that notion of the number of units that had existed, it was illegal. And I note that there have been some changes and adjustments in terms of the number of units, and I heard Attorney Fitzpatrick's remarks that he had made to the commission, and now there's some reduction in the number of units. There's only going to be 1 unit in the so-called onion barn and so forth. But once again, the applicants are before you, and I suppose I should emphasize that this is not about denigrating the applicants, as Attorney Fitzpatrick had suggested in his remarks, and certainly his clients are entitled to the fair and legal use of their property, and no one questions that. But really, this application should be denied because it doesn't meet your subdivision regulations. Now, another reason my clients are here on Sasko Hill Road, and I learned a lot from the presentation, is because Sasko Hill, in many ways, is not unlike any other neighborhood in Fairfield, with the same sorts of concerns that this commission hears when there's a subdivision or an activity proposed. And in some ways, it's unique. Its charm and its beauty are unique. I mean, it is a treasure in this town. It's a beautiful street, and one that I know we're all proud of. I suppose I can also say that it's unique in that few streets are as heavily taxed per parcel as Sasko Hill Road, and while that doesn't immediately factor into the jurisdiction of this commission, it raises some interesting issues. Right at the moment, there are a number of properties for sale on Sasko Hill Road, and there is concern among the applicants as to the subdivision of property on the street, the effect on the character of the street, the effect on property values on the street. They're motivated just like neighborhoods all over Fairfield. And I know that this commission is mindful of those concerns in terms of how property is subdivided, the use of property in Fairfield, the overuse and overdevelopment of property in Fairfield. And let's talk a little bit further about Sasko Hill Road, because frankly, you have a street that is heavily traveled, and it struck me when Mr. Galante sort of casually mentioned that this is a street that is traveled over by, I think he said 1,200 cars a day. It's a street that at one end is the Post Road, and we're all familiar with that intersection, and at the far end is Sasko Hill Beach, which is a popular beach. And I can tell you that there are several days in the summertime on a weekend, and I think he spoke in terms of weekend traffic, when you can't get into Sasko Hill Beach because the parking lot is full. It's heavily used. It also has a country club on it, and while it is a private country club, the Country Club of Fairfield, like many country clubs, has functions there. There are charitable functions. There are golf tournaments that are available to the public. It is heavily used. Another unique factor about Sasko Hill Road is with 1,200 cars and with traffic, and I heard an average speed of 34 miles per hour. There are areas of Sasko Hill Road that are 20 feet wide. 20 feet wide. And even on the applicant's drawing, I note it shows one portion of the road right on the site plan that says it's 22 feet wide. And I was actually at a function not too long ago on Sasko Hill Road, and it was a fundraiser and it was a charitable function. And someone had it at their home, and it was well attended. And what ended up happening was a lot of the attendees had to park on Sasko Hill Road. And the fact of the matter is, when cars are parked on the shoulder of Sasko Hill Road, including, I noted at this function, one of the companies, maybe it was the caterer's van, I don't know, but there was a truck parked on the road out of the driveway, and a line of cars. And while there was a police presence there to direct traffic, only one car could go each way in and out of Sasko Hill Road. There was one-way traffic because the road is not wide enough in certain places. So when you start to say to the residents who live there, we're going to subdivide a property, they start saying, well, there are a lot of properties for sale on the road. Are every one of those properties going to get subdivided? Are we going to increase the amount of traffic? And it is a problem. And once again, it is charming, it is beautiful, we're all proud of it. I mean, I don't live there, but I can tell you, I've run down there, we've ridden bikes down there, and it is a popular destination. But make no mistake about it, access and traffic are an issue, and you heard it. You've heard it before when One Sasko came in with its application. You heard several residents appear before you and say, "Boy, in the morning, the amount of cars trying to get in and out, trying to get out of Sasko Hill Road to get on the Post Road to head west. Then certainly in the afternoon, there's a lot of traffic that goes to Oldfield Road and travels over that road." So there are issues. And so Sasko Hill Road residents share many of the concerns that residents share all over Fairfield. And I understand that this commission is sensitive to those issues. You've been responsive to those issues in terms of adopting regulations regarding the subdivision of lots that affected this zone. And we certainly appreciate that. And once again, Mr. Fitzpatrick's clients are entitled to the legal use of their property. But I would suggest, first of all, that this application requires the same level of scrutiny as any other application, and it should be a high level of scrutiny to assure that it meets the regulations. And if you do that, acting in your administrative capacity, you can't grant this application. Now, Section 1 of the subdivision regulations, including specifically Section 1.1, refers to requirements for consideration, and it says, "Before the commission shall consider any proposed subdivision, the following shall be submitted." And there's a map, and under 1.1.3b, it says, "A subdivision map showing the following." And it says, under B, existing and proposed street lines, lot numbers, and appropriate lot areas. And I note that the subdivision map, and the map that was submitted by this applicant, shows Sasko Hill Road. However, street lines are not defined as the paved portion of the road. Under the zoning regulations, street lines are defined as the right-of-way, and specifically under definitions, and it's 31.2.36 says street line, and it says the definition is the right-of-way easement or taking line of any public or private street, or of any easement of access or private right-of-way 25 feet or more in width. Now, this is a public street, and the right-of-way or easement line, I note, is shown apparently on the east side of Sasko Hill Road, but there's no showing of where the easement or right-of-way line is on the west side of the street. And all that's shown is, or purported to be shown, is the paved portion. So let's talk about that. Among the considerations that you must define or must determine in ruling on this subdivision application, in section, once again, 1.1, says that before the commission shall consider any proposed subdivision, the following shall be submitted. 1.1.6 says design and improvement standards. And it says all plans submitted in conjunction with subdivision applications shall meet or exceed the map design and improvement standards found in section 2.0 and 3.0 of these subdivision regulations. So where are we going? The essence and the critical regulation, subdivision regulation, that this commission should look at and that this applicant has not apparently considered is section 2.1.10 of the subdivision regulations. And what does it say? It says existing streets, and here we have Sasko Hill Road, an existing street. A proposed subdivision abutting an existing town street shall provide for proper construction and widening of said street to 50 feet or to a greater width, depending upon the classification given said street by the commission. The commission may modify this requirement in its discretion. In this case, you can't determine, based on the application that's been submitted, what the width is of the right-of-way. It hasn't been submitted, it's not furnished, and it is a specific requirement of your regulations. Now, let's go a step further. I've been before this commission, and I've spent a considerable amount of time sitting here, listening to the remarks of this commission. And one of the areas of concern that I've heard from this commission consistently are concerns of pedestrian access. I've seen this commission and heard this commission recently where the commission has talked about drawing the line on sidewalks and on access. And those are important considerations, particularly where you have a road that leads to a beach, where you have a road that is used heavily, admittedly by this applicant, by 1,200 applicants, and on a weekend, 112, I thought it was, I'm not sure, it was 100 and somewhat figure. Just to get it right. Peak on a weekend was 112 cars in an hour. 112 cars in an hour. Maybe there are concerns that this commission should have regarding access, regarding sidewalks, or regarding provisions. I note that I was before the commission back in September, and I think you were dealing with a subdivision on Bronson Road. And I'm not directly familiar with the application number or the plan, but I heard remarks by the commission. I made notes that night where one commissioner said, I don't waive sidewalks. 2013 is the year. We have to start somewhere, and we have to start creating these provisions. And maybe 2013 is the year. And while I'm not suggesting that this applicant has to place sidewalks here, What I am suggesting is we have to start at some time creating the kind of rights-of-way that create the kind of amenities for proper planning. But the fact of the matter is that the applicant has not provided you with any basis upon which you can find that there is a 50-foot right-of-way, nor can they show you that they've created a provision to create a 50-foot right-of-way. Now, Section 8-25 speaks of the Connecticut General Statutes, and I note that Attorney Fitzpatrick, I think, offered it on the previous application, so I know you have it before you. And it says specifically, as part of that legislation, before exercising the powers granted in this section, the Commission shall adopt regulations covering the subdivision of land, and no such regulation shall become effective until a public hearing, and it goes on, and it provides the standards. So you have the regulations before you, and the applicant has failed to meet its burden in showing that to you. Just one moment. The Sasko Hill Neighborhood Association retained the firm of Nowakowski, Obemishow, and Kane. This is a drawing that has been created that shows the right-of-way of, the first page shows the right-of-way of both the McDonald property, and it also shows, and using historic maps, surveying, and gathering data, it shows the actual right-of-way of the west side of the street. So this first page depicts the right-of-way on both sides of the street, which the applicant had failed to do in this application.
Where's that map?
I'm sorry?
You're submitting this to them?
Yes,
You have copies?
I do. Actually,
Like copies we can look at on our table?
I can see that from here. I mean, I can see it, but I can't. That would be great.
I mean, if you submit the exhibit to staff, that's fine, but it's much more helpful for us to have to take something home with us. Yeah.
Thank you.
so the first page, and I'm referring to the ledger-sized drawings, the first page is basically a site plan that shows, that depicts the right-of-way on both the east side of Sasko Hill Road and the west side of Sasko Hill Road. And it shows also the edges of the pavement, just for the orientation of the commission. And you will note that there's actually a spot in front of the subject property where the road goes down to 20.1 feet wide. The paved portion of the road, to be accurate. The second page,
This was prepared by the association for the purposes of this?
correct, it was prepared by Nowakowski, Obemishow, and Kane, commissioned by the association.
It's dated today, apparently.
It was, yeah, it is dated today. The second page shows a 25-foot line from the center line of the right-of-way. And I think a fair reading of the requirement of creating a 50-foot right-of-way is that it would emanate from any expansion, wouldn't be borne by one property on one side of the street, but it would really be consistent to create an expansion of the right-of-way 25 feet from the center of the existing right-of-way. So basically, you'll see the blue or purple line on the map depicts a line that is 25 feet from the center line of the right-of-way.
Yeah, sure. Subdivision regs?
So this line shows 25 feet, and you can see then that the applicant who created this, what I'll call the front lot, did not allow any margin of error at all, and that lot by its design, was only 2.000 acres. And in order to create the 50-foot right-of-way that is required under the subdivision regulations, they would have had to pull back their measurement line or the property line to accommodate the widening of the right-of-way. The next page is a sort of an expansion for the benefit of the commission, and you can see this is depicted in a larger scale that, again, shows where the 25-foot line is from the center line of the right-of-way. And then, even if we were to use the center line of the pavement as a reference point, the last page, you'll see a red line, and, we had this drawn. I don't think, for purposes of the regulations in Fairfield, again, it refers to the street line as the right-of-way, not the paved portion, but we prepared this drawing just to illustrate to the commission 25 feet from the center of the existing pavement to give the commission further reference and further information on this.
Mr. Green, there's some new information here.
Yeah.
25 feet, the line you're saying would kind of, if they did it from the center of the road, would go into the McDonald's current property.
Correct.
The property be subdivided.
Correct.
They would have to take away some of their lot to provide that.
Correct.
On the other side of the road, which is the Country Club of Fairfield, I guess is across from
Correct.
this, is there 25 feet also to their property line, or I mean,
If
could they
the,
provide
if the
50?
country club were to subdivide or to attempt to,
Hopefully not, but, yeah. Okay.
well, I understand that, but the subdivision regulation that exists would say,
I don't think that's a question. I think if it's 50 feet.
Yeah, it's 50 feet, yeah.
Sorry,
Yeah.
thank you.
Yeah.
If it's 50 feet that you're suggesting and you're showing 25 feet on one side,
yeah.
what does the 25 feet look like on the other side? Does
Yeah.
it go to the property line of the Country Club of Fairfield?
Oh, no,
or would
it exceeds, it goes into the country club property as well.
That's your question.
That was my question. I
Yes,
said,
the answer
how do
is,
you, because the
the
regulations
answer is,
say 50 feet.
the answer is yes, it does. It would take away from the country club's property in the front as well. However, in view of the fact that the country club is not looking to subdivide its property, it wouldn't invoke the regulation.
Right, but the regulations that you cited, I'm sorry, in the packet says that they have to provide a 50-foot street width. I'm saying, and I'm just questioning to learn about this, not disputing what you're saying.
Look,
You've got 25 feet, but
Instead
don't
of-
you interpret that it has to be 50?
Okay, so instead of measuring from, for example, the boundary line of the right-of-way in front of the country club and measuring 50 feet into the McDonald property, we were of the opinion, and the commission may disagree and say it has to be 50 feet, but we were of the opinion that it was probably a more workable or more fair solution to take it from the center line of the right-of-way and burden each property,
And what's the basis of that?
because otherwise you would end up with an odd, as lots got subdivided, you'd end up, I think, with an odd result in terms of how properties lined up and how the right-of-way was created.
It also says,
However, however, under any circumstances, even if the commission interprets it that a 50-foot is required and literally reads the regulation, then the more of the McDonald property would be occupied to accommodate a 50-foot.
it also says the commission may modify this requirement in its discretion.
It does. It
Which I'm
does,
sure
and I'm
you'll-
going to get to that.
And if we decide to modify it,
Yes.
just for sake of argument and want to approve it, should this commission impose sidewalks along this property, only on this property on Sasko Hill Road?
I can't-
that what your client wants?
I'm not taking a position on that. I don't think that it would be a sidewalk that goes anywhere at this point, so.
I know.
I'm not suggesting that, but you raise a very good point. Because Section 8-26 of the Connecticut General Statutes, and I've provided the commission with a copy of it, and I've highlighted the language. And I provided each of you with a copy of 8-26, and it says,
Where?
in the documents that I just provided you, there's a copy of the statute among the documents.
It's this.
And it's important.
Okay, I've got it. It's the
And
last
what it
page.
says is, amongst the language in 8-26 is, it said, "Such regulations may contain provisions whereby the commission may waive certain requirements under the regulations by a 3/4 vote of all of the members of the commission in cases where conditions exist which affect the subject land and are not generally applicable to other land in the area, provided that the regulations shall specify the conditions under which a waiver may be considered, and shall provide that no waiver shall be granted that would have a significant adverse effect on adjacent property or on public health and safety." And it says, "The commission shall state upon its records the reasons for which a waiver is granted in each case." Now, Section 4.0 of the subdivision regulations of the town of Fairfield say, "The commission, upon written request from the applicant by a 3/4 vote of all members, may modify or vary specific requirements herein with respect to a subdivision, where owing to conditions especially affecting such subdivision, a literal enforcement of these subdivision regulations would result in practical difficulty and unusual hardship, so that substantial justice will be done and the purpose and intent of these subdivision regulations secured. No waiver shall be granted that would have a significant adverse effect on adjacent property or on public health and safety." In this case, first of all, this regulation does not contain all the requirements of the Connecticut General Statutes, but more significantly, in this case, the applicant has not, as part of this application, requested a waiver, so that was never part of this application. Secondly, it can't meet the standards of your regulations. In other words, first of all, that subdivision regulation affects all the properties on Sasko Hill Road, so it's not unique to this property. It's not unique to this property. And also, finally, even if the applicant had asked for a waiver, even if the commission found that we want to keep narrow streets and we want 20-foot wide streets where the average traffic is going 34 miles an hour, and that serves 1,200 cars and serves a country club and a beach, even if the commission thought that was a policy, which clearly it doesn't, and I'm being facetious, this is totally inconsistent with the policies that you have expressed in the past regarding access, regarding starting to plan for the future and creating at least an opportunity for future planning for access and that sort of thing. So I think it would be inconsistent with your policies, but it hasn't been asked for anyways as part of this application.
Okay, Mr. Wagner.
So, just from a technical application standpoint, do you think that it's significant that 1 point, whatever the 50-foot street numbered regulation is, contains a specific clause that provides that we may modify in our discretion as
Right.
opposed to waiver under 826?
Correct.
Do you think that's significant? I'm asking as a point of distinction as between a waiver of a regulation and a modification which is subject to our specific discretion.
Well,
Do
I
you
have-
think that's significant?
I think it's a good question, and I would answer it this way. First of all, there's recent case law that says there is some concern where zoning commissions have discretion, because as you know, under 8-6, it's the Zoning Board of Appeals that can waive and vary the zoning regulations. So there's recently a case that came down in Monroe, and I actually have a copy of it with me this evening. I may not,
What did it stand for?
Kevin Gumper is going to want to punch me because it was his case, and what it had was, I believe it is actually, I cannot remember the case, but it's versus the Monroe Planning and Zoning Commission, and what it stood for was there was an issue where McDonald's was seeking to create a restaurant on Route 25, and the commission, in granting the special exception permit, waived certain landscaping and buffer requirements. And the import of the case was that a zoning commission can only has power to act sort of as a quasi-ZBA, where statutes specifically authorize the commission to do that. It has to be a specific delegation of authority. And therefore, in this case, I would submit that the only basis upon which this commission could act as a ZBA or exercise the power to vary or waive the
There's a difference between a modification and a waiver, though. Wouldn't you agree?
I don't necessarily agree.
Okay.
Because I would say that the authority of the commission emanates specifically, 8-25 talks about adopting subdivision regulations, and it says that no subdivision shall be allowed except in conformity with the statute, and in conformity with the regulations that are adopted. The name of the case is?
I don't know the name of the case, but I can probably help you a little bit, Mr. Wagner, Mr. Green, with this. I'm sorry, you were asking me the name of the case?
May I raise a point of information and ask Mr. Wendt what the name of the case was? Because somehow I think he's familiar with it.
I don't know the name of the case.
Okay, well, I'll just a couple of points is that first, where we're talking about, in the language where they talk about modify or vary or waiver, it's a little, I don't know the legal differences here, but I'll tell you, 4.0, the only time it's ever, in my recollection, 10 years, has ever been used or asked for is with sidewalks. And sidewalks only apply so far to our A, B, and C zones. They don't apply to AAA. So when you say, can we ask for sidewalk? My opinion is that we can't require sidewalks in the AAA zone because there's nothing in our regulation that says we can. So people use that for that, whether there's modify, waive, I'm not clear. But I believe that the ZBA has no authority you can't grant variances against our subdivision regulations, only our zoning regulations.
Right.
So that section 4 applies to the technical requirements in here are not something that the ZBA can waive, we have to. So if we just say this is, this street doesn't need sidewalks because whatever reason, we have that authority to do it. The word waiver is a little confusing there because I don't think of that as a waiver, I think of it as a modification of requirement. But you guys as lawyers will help me out, but what I know is that that's how it's used.
Well, right, yeah.
And it's because the ZBA can't do it, we have to do it.
I can appreciate that. I mean, right now, I'm asking Attorney Green what his impression is and whether there is a difference between a modification and a waiver.
First of all,
I can then take that home with me and try to figure it out for myself.
well, let's go back. The name of the case is Donna McKenzie versus Planning and Zoning Commission of the Town of Monroe. So that's the first, we can solve that problem. The next issue is there has been no request for a modification in writing as part of this application. So you don't have to worry about that because it was never part of the application.
Let me finish.
Okay. Well, I mean, the text of the regulation does not require that the applicant ask for the waiver, does it?
I would suggest that I don't know that this commission, I believe that 8-26, which talks about approval of subdivision and re-subdivision, and that waiver.
Yeah, I'll give you.
I don't know that the commission does have the unfettered discretion to just, on its own, modify that requirement.
2.110 says that we do, it just says that, but section 4 is what says upon written request of the applicant. Mr. Wagner has the regulations if you want to interpret it or read it or ask questions about it. So one part, the part which says condition of variance does refer to upon written request of the applicant. The section you cited just says the commission may waive it upon its discretion. I don't know the difference, but we're delving into
Okay.
to new stuff. Mr. Cannelli has a question?
Well, I just, do you mind just, because you may, okay. All right. The modification or waiver issue, kind of for me, is cart before the horse. Let me understand something. I'm not an attorney, Mr. Green. We're all, you know, the commission is in what amounts to kind of the Pansy Road LLC box, the Weatherly box. And that is at the end of the day, my understanding in our administrative capacity, we have to look essentially what's on the site. 34 miles an hour is speedy, but on the other hand, the reason for that number is to provide the sightline distances for, was to provide some way to calculate the sightline distances, in which case the applicant has met those sightline distances. That's why we're concerned about speed. Now, you make good points, and I do care very much about the issues related to traffic congestion and all the rest, but here's what I'm asking you. It appears that you seem to have offered a new, or at least new in terms of what I've heard over my 6 years on the commission, and I'm hopeful that there's case law supporting this. Should this be, because what you're presenting to us would appear to be a basis for administrative denial. Am I correct in understanding that you believe under our subdivision regulations, in our administrative capacity, we can say that if this 50-foot wide right-of-way is not provided on, in the road in front of the subdivision, and it can be calculated in the conservative manner you provided, which is at the center, or that, in fact, that is a legally justifiable reason within our administrative capacity to deny this application?
Absolutely.
Okay, so that's really, in other words, if we felt that you believe that's your contention, that if this were to be appealed, that the town attorney would be on firm footing looking at the legal justification you provided, that this indeed is a reasonable position for us to take in our administrative capacity. This is an off-site, this is part of the site. In other words, if I'm going to create a subdivision, if I've created that subdivision and I don't provide the 50-foot right-of-way, then that's an element, in your opinion, or at least what you're presenting to us, of what I must consider as a commissioner in my administrative capacity to approve or deny a subdivision.
Yes.
Okay, that's all.
And the
And you
applicant never...
view that as legally defensible? Is there any case law or past instances where, well, I guess it's our regulations, but I don't know.
I rely on
similar
the same case law that Attorney
No,
Fitzpatrick cited.
right. So as long as it's in the subdivision regulations and the 50 feet is there, your view is that's a reasonable basis for,
Yes.
under the administrative capacity to do so. Okay.
And in fact, it says that under section 31.2.21, under lot area and shape, in determining compliance with the minimum lot area and shape requirements of the zoning regulations, land subject to underground easements may be included, but no street or highway easement for vehicles or easement for above-ground public utilities may be included. So it's not included in the measurement of the lot.
But your point about making this measurement from the center of the right-of-way, the center of the roadway, is that it would be a fair standard for us if we were considering subdivisions all the way down Sasko Hill Road. That's your point. In other words, you're asking for what you think is a neutrally applied standard in that area or any area going forward, that you'd have to have this particular right-of-way.
As subdivisions come before you,
Right.
just as I heard this commission comment on other plans involving other properties in other places, it's got to start, and it should start. Well, this has been raised, and I think the commission should start planning for the future and should start imposing this regulation and requiring it so that ultimately the commission in the future will have, the town will have the right-of-way that meets the standard.
And you believe that this right-of-way requirement in the subdivision regulations has the same force of law for us in our administrative capacity for denial as, say, a setback that can't be met,
Sure it does.
or issues like that? Okay,
Sure
just,
it does.
thanks. I just wanted to...
So, help me understand then the legal basis for requiring 25 feet on one side and not on the other, or 50 feet when the regulation says 50 feet.
I agree with you. A strict reading is 50 feet.
Okay.
And you are correct, and your reading is correct, and your questioning of me as to why it was 25 feet is correct. I was just in terms of a practical outcome that would create contours and appropriate contours on both sides of the street, and you wouldn't end up with 50 feet on this property and 50 feet into this property and end up with a patchwork. I thought the commission might if this had been requested, or if the commission was exercising its discretion, would say, we're going to start widening these roads and burden the owners on both sides of the property, of the road equally, to create a well-contoured right-of-way, and not take 50 feet off of this property, and then if this property were to choose to subdivide, digging 50 feet into this property, and you'd have properties that didn't transition smoothly. So that was, and frankly, that was my thinking. And I thought that was a fair sort of interpretation. Now, I know your next question is going to be, well, you're suggesting then that we modify or waive. I'm not. And if the commission, I agree, the literal reading is it's 50 feet. But let's just get beyond it. And when we may disagree on the 25 and the 50, and that's fine, but one thing's for sure, the applicant came before you.
I mean, the bottom line is, and I don't want to make your argument for you, but you kind of went one step too far.
Correct.
Because you didn't have to go there.
That's correct.
In order to make your point, and...
That's correct, because it's 2.000 acres. So if there's 1 square inch that comes out of this property, whether it's by virtue of the commission saying 25 feet or 50 feet, you don't even get there, because the lot is too small and it's not subdividable into that lot. So you are correct. I went one step too far, but I think we had a good discussion, and I think it raises a lot of interesting issues for future planning, and I appreciate the thought, and I appreciate the position that you've expressed, that it does say 50 feet. And maybe in the future, the commission may choose to modify that subdivision regulation. But again, you are correct, going back to it, there's not 2 acres here to subdivide to.
Yeah, sure. I just point out it actually says 50 feet or to a greater width.
Or to a greater width.
Yeah. Yeah, that's a literal reading.
And by the way...
The greater width, it relates back, and that's why I went back to the other regulations. So the streets are codified, and so a local street is 50 feet, a town street is 60 feet, et cetera. So the smallest is 50 feet, which is why the regulation says shall be 50 feet or wider, the implication being according to whichever kind of street it is.
And I was struck that the applicant has a traffic consultant that gets up and says 1,200 cars a day. That's a lot of cars. And maybe that is not a local street. Maybe that does qualify as a secondary thoroughfare.
Well, I mean, I don't think that, now we're really getting beyond any kind of knowledge I have, but I mean, I don't think that the definition of that street as a local or a town street has to do with the traffic so much as it does with the area map and what we've designated those side streets and town streets and
Absolutely correct.
Whatever as, yeah.
Go ahead, Mr. Kennelly.
Yeah, thanks. So one other point I thought I'd ask is the applicant has said to us that since the previous application was rejected, and he believes the attorney for the applicants believe that those issues have been addressed, that we would have to, if those issues have been addressed, now support this application.
I don't.
You've now raised what appears to be something that wasn't in there wasn't a discussion about this before.
Well, I know
Do you
that...
think we're legally bound?
No, I don't.
I'm not a lawyer.
I don't agree with that position, and this is not the same application, and there are features that are new to this application, and also, frankly, I'm appearing tonight on behalf of a different mix of representing others than I appeared before you in the past, and I think this is an issue that's fairly raised, and you are not bound by the denial of the previous application. It's not the same application.
Okay. Any other questions for Attorney Green, or then we'll let you just proceed?
Yeah. Is that it? Is that the basis for your argument for denial? We have, I think, reduction in property values and failure to show the street lines,
Well,
right of way.
okay, so there's...
And as a result of that, then also the failure to show the 50-foot roadway.
Okay, so there's first of all that the applicant has failed to meet its burden in providing the commission with all the information under Section 1 of the subdivision regulations. So the application, and it says in the subdivision regulations that the commission shall not consider an application which does not contain this information. So that's step one. Step two, we have provided evidence that this subdivision does not meet the standards because the lot is too small. It doesn't have 2 acres as defined in your regulations for lot size. Also, there's been no request for a waiver to waive or modify the regulations, so that's not even before the commission. Moreover, the applicant has not put any sort of a presentation together that talked about property values, that talked about the kinds of things that this, even if this commission were to go beyond and say we want to consider waiving or modifying, the applicant A, didn't ask for it, but B, made no presentation as to show how this property is uniquely affected, so that wasn't even part of the application. And
The lot size argument is as a result of the 50-foot, because if they need more space, then the lot size doesn't conform. I mean, you're not arguing that the lots as presented in this new revised application do not contain sufficient square footage to meet the regulations as they've proposed them, taking out of consideration this 50-foot road argument.
no, I don't.
Right, okay.
But again, once again, there's been no presentation upon which this commission could find hardship or that this property is unique or uniquely affected or any of the sorts of things that this commission, that we believe this commission would have to find to waive or modify the requirements of the subdivision regulations.
Question?
No, okay, that was Mr. Wagner.
So I certainly want to thank you for your patience and the attention to the details that we've raised. Thank you.
Thank you, Mr. Green. Any other members of the public who wish to be heard on this matter? No one does. That's okay. I just wanted to know that once we go back to Mr. Fitzpatrick, he has the last word, and he has a right to rebuttal, or if he wants to ask. Let's rebuttal tonight. You can do that, and then we close the hearing. That's the way our...
Mr. Chairman, I would like to submit those documents that I promised to submit earlier.
Thank you.
Thanks.
Yeah, same thing.
You know what?
You need-
go back and say something my phone system as well. So,
Yeah.
I'm not sorry, keeping this up for the record.
Yeah.
Mr. Chairman, I'd like to request that this matter be continued. There's been information submitted, new information of a technical nature. Certainly, my client deserves the full and fair opportunity to review that evidence and analyze it. It's technical, can't do it on the spot, and I'd request this matter be continued to the next available hearing.
Yeah, and I see no reason why not to grant it. We have 35 days, that's actually the only consideration we have, which is, before I agree to this, is that our next meeting is not for 4 weeks. Would we be able to schedule, it's December 10th, is that correct? So, do we see that as a problem? I mean, you can actually give us, say that I believe that we can have more time to complete it.
I have already given, I believe, an extension on this application of the maximum time frame within which to complete each statutory requirement. I don't know where we...
Right, so if we complete it that night, if we can get it on the schedule, complete it that night, there'll be no extension necessary.
Fine.
If we can't complete it that night, for some reason you can't be there, we can't schedule it, then we'll need you to agree to an extension. Which
I understand.
I believe you would want to do.
Correct.
Okay.
Yes, Mr. Green?
If I may, Mr. Chairman, just as a matter of process procedure, as you're aware, this commission is governed by the rules of fundamental fairness in terms of how it handles applications and procedure. This is a public hearing, and I think I point out sometimes to certain commissions, it's not, public hearings are not workshops, they're public hearings. So one of the things I'm concerned about is that the public has gotten up and pointed out that this application is missing certain information, that the applicant has failed to meet its burden and so forth. So I certainly think it's fair for Mr. Fitzpatrick to, assess the arguments that I've made, but what I think would not be fair would be for the applicant to submit a new application, new information, modify its application, because our position is basically that the applicant had failed to meet its burden on its presentation. So while Mr. Fitzpatrick may want to bring an argument forward, I don't think it would be fair of this commission to start accepting amendments, modifications, or new materials that weren't originally submitted.
Okay, I understand. We'd have to see what he submits. I say our rules, like you say, are governed by fundamental fairness, so I'll say this based upon past actions that we've done here. Mr. Fitzpatrick comes in and submits a rebuttal, it just talks about, you know, whatever he does, if it's not really new evidence or anything like that, if it's just a rebuttal, then we'll just hear what he has to say and we'll close the hearing. If we get new evidence that we deem as, you know, new evidence, we'll let the public chance to respond. If we're saying we get like something, an entirely new application or something different, I don't know what we'll do then. If we get modified application, we'd have to decide that. But all I'm saying right now is he's asked to continue the hearing, it's his right, and I'll grant that for his rebuttal. But we are officially in rebuttal time now.
So it's rebuttal, but
Correct.
that's my point, is it wouldn't be a new application or a new...
If I may.
Yeah, sure, Mr. Webb.
You're sort of making this into an issue that, that doesn't possibly need to be made an issue.
Okay.
Okay? It's his time for rebuttal. You raised new arguments that were never presented before, and appropriately, he asked for an opportunity to consider those and rebut at the next meeting. That's what he asked for. Rebuttal.
Rebuttal.
Okay?
That's fine.
So, that's what we're
Thank
expecting.
you.
Like I
Thank
said,
you.
yeah, if we get a bunch of, if we get some modification, new documents, we might allow people to ask questions about it, but we'll have to see what comes. It's
Exactly.
a rebuttal.
It's where we are.
Yeah. Thank you. I will adjourn for the night.